Good morning, everybody. My name is Kate Fielding and I work here in the HR services team here at Co-operatives UK. Welcome to our webinar this morning on avoiding discrimination at work. Today, Gary Morrison, who is our senior employment lawyer, is going to be talking to us about discrimination. We'll start with a few. Are you all right, Gary?
Yes, yeah.
Sorry. Sorry. We'll start with a few slides and then we'll move into a Q&A session. We do have some pre-prepared questions. If you have any general questions about discrimination law, please do ask them in the chat box at the bottom. We're not able to give specific legal advice on the webinar today, so if you do have any specific questions and you're a member of Co-operatives UK with either the HR or the contact, please do get in touch with us after the webinar and we'll be happy to talk those through with you. We're going to be recording the webinar today, so we'll send out a copy of the recording along with the slides within a week or so of this finishing. If you've got any colleagues who wanted to be here today but haven't been able to make it, then please do share that information with them. As I say, we've only got an hour today, so it can only be a really brief introduction to discrimination law, which is obviously a very detailed and important part of HR law. Gary's going to talk about discrimination, what we mean by that, what constitutes discrimination, what's covered by the Equality Act 2010. We'll look at the 9 protected characteristics, and then we're going to take a more detailed look at 2 of those characteristics, disability and pregnancy and maternity, because they're the ones that we think you're really likely to come across at work. We'll look at what constitutes in discrimination in those areas, some of the things that you really need to look out for, and also some of the common mistakes that employees can fall into. As we go through, you're quite likely to hear either Gary or myself talk about employees. That doesn't mean that what we're talking about today isn't as relevant to you if you're a worker co-op. Discrimination law is relevant to every employer in this country, so it's just as relevant to worker co-ops as to other types of organisations. Just before we get started, I'd really like to find out a little bit more about who you are and your experience of HR. So I'm just going to run a quick poll, which hopefully you can see now, just to explain to us about what you do in your day-to-day role. Right, that's brilliant. Thanks, everybody. It's really great to see that we've got such a wide range there of experience in HR. So I don't know if you can see Gary, but we've got a few people who do HR as part of their full-time role, but we also have quite a lot of people here who manage HR as part of a team, so that's fantastic. I'll just end that now. And I'm going to hand us over to Gary, who'll get us started.
Good morning, everyone. As Kate says, this morning we're going to look at discrimination, what constitutes discrimination, and we'll look at what the 9 protected characteristics are and the different types of discrimination. And then we'll take a look at 2 areas of discrimination that we think you're quite likely to come across, which relate to disability and pregnancy and maternity. We'll look at what we mean by discrimination in these areas and some of the duties that employers are under in relation to those areas, some particular requirements to look out for, and we'll finish with some common mistakes. So if we look at some of the possible consequences when employers get it wrong in terms of dealing with employees with protected characteristics and when unlawful discrimination occurs. The financial consequences are potentially significant in that, unlike what you might call a straightforward unfair dismissal claim, where the award has a statutory cap, currently it's 88,000, which isn't insignificant, but at least there is a cap on that. Awards in discrimination claims are uncapped, and where an employment makes a finding of unlawful discrimination, as well as awarding potential financial losses, it's also bound to make an additional award of injury to feelings. However, financial penalties aren't the only consequences of unlawful discrimination. There are also commercial concerns, not least in the finding of unlawful discrimination itself and the potential reputational damage. But also, if you're tendering for work from other organisations, some bigger organisations that you might be tendering to work from will ask whether you've had any findings of unlawful discrimination against you. If we look at the legislation and the Equality Act of 2010, that contains most of the current legislation in terms of discrimination. I mean, domestic law has developed over more than 40 years since the first Race Relations Act in 1965, and subsequently other characteristics besides race have been protected from discrimination. Sometimes these are as a result of UK domestic initiatives. Sometimes they've been implemented because of the requirement to do so because of European directives. Like I said, the domestic law is now effectively contained in one piece of legislation, which is the Equality Act of 2010. And that sets out 9 characteristics which are protected against unlawful discrimination. Those characteristics are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. Yeah, there are 9 protected characteristics, and the Equality Act also sets out the types of discrimination which are prohibited as unlawful. These include direct discrimination, indirect discrimination, harassment, victimization, and in respect of disability discrimination, there are additional types of conduct which are unlawful, and these are discrimination arising from disability and a failure to make reasonable adjustments. Discrimination is a very wide-ranging area, and in this particular webinar, as Kate said, we're going to look at 2 areas, I think they're highlighted on the earlier slide, where discrimination seems to arise more than others, and we're therefore looking in particular at disability discrimination and the right to make reasonable adjustments, and also discrimination on the grounds of maternity or pregnancy, which is unlawful under Section 18 of the Equality Act. Just by way of explanation, direct discrimination is where someone is treated less favourably because of a particular protected characteristic, or even because someone thinks that they have a protected characteristic. Indirect discrimination occurs when a requirement or a rule that appears to be neutral and is the same for everyone, in fact has the effect of disadvantaging someone because they have a protected characteristic. So the rule isn't singling someone out, it's applying a rule to everyone, but the rule has a disproportionate effect on someone because of the protected characteristic that they may have. And unlike direct discrimination, indirect discrimination can be justified if that requirement or rule in question can be shown to be a proportionate means of achieving a legitimate aim. That's what an employer would need to show if it had imposed a rule that was affecting someone disproportionately and adversely because of a protected characteristic. If the employer could show that it was a proportionate means of achieving what would be a legitimate aim, then that indirect discrimination can be justified. An example of indirect discrimination may be advertising for a position and including a minimum height requirement for the job. If a minimum height requirement can't be justified, you could be indirectly discriminating against women, given that women are typically shorter than men. You could, in fact, be discriminating against certain ethnic groups on the same basis. But if you can justify that requirement, then you should be able to defend any challenge on the grounds of indirect discrimination. Harassment is unwanted behaviour related, again, to one of the 9 protected characteristics. And harassment is defined as something which is offensive or which creates an intimidating, hostile, degrading, humiliating, or offensive environment. The harassment can only occur if it's in relation to a protected characteristic. Victimization is another form of discrimination. This occurs if a person is subject to a detriment because they've complained about discrimination, or where perhaps they've supported or given evidence on behalf of someone who has raised a claim of discrimination. People use the term victimization quite widely, but in legal terms and employment terms, it's got quite a specific meaning. Victimization can only occur if you've done what's called a protected act, and that protected act might be to have complained about another act of discrimination or supported someone, and then you're treated less favorably as a result of doing that act. You are victimized as a result of doing that act. Discrimination arising out of disability is another form of discrimination, and it's where an employer treats an employee unfavorably because of something arising in consequence of the employee's disability. But like indirect discrimination, it can be justified if the employer can show that the treatment is a proportionate means of achieving a legitimate aim. In other words, the employer must demonstrate that the measures taken were reasonably necessary in order to achieve a legitimate aim. Might be a business need, might be a health and safety requirement. An example of discrimination arising from disability might be an employee who has a condition which is a disability, which necessitates perhaps absence for treatment, and then those absences are taken into account for perhaps the purpose of a bonus payment. The fact that the absences are taken into account and the bonus payment may not be paid have resulted in the less favourable treatment. And that less favourable treatment is linked to the disability. It's not directly because of the disability, it's because of the absences caused by the disability, hence the introduction of that particular type of discrimination, which is discrimination arising from disability. So what is disability? So looking in particular at disability as a protected characteristic, the definition of disability is set out under Section 6 of the Equality Act, and it states that a disability is a physical or mental impairment which has a long-term adverse effect on the ability to carry out normal day-to-day activities. So it's judged on the ability to carry out day-to-day activities. It must be long-term, which is defined as lasting 12 months or more, or likely to last 12 months or more. It must have a substantial adverse effect on that person's ability to carry out those day-to-day activities. It means it must be more than minor or trivial. It must affect their ability to do things on a day-to-day basis. One of the most common types of disability discrimination we come across more and more is a failure to make reasonable adjustments. Section 20 of the Equality Act imposes a legal obligation on employers where the employer has in place what's termed as a provision criteria or practice. That's essentially a way of working, perhaps a policy, perhaps an instruction, but a way of working which puts a disabled person at a substantial disadvantage compared with other people who aren't disabled. So you've imposed this provision criteria practice which everyone's got to comply with, but it's affecting the disabled person more and putting them at a substantial disadvantage compared to others who aren't disabled. Where that occurs, the employer under Section 20 is obliged, legally obliged, to take such steps as it is reasonable to avoid the disadvantage caused by the disability in complying with that, what they call the PCP, provision criteria practice. Reasonable adjustments are therefore adjustments which will enable an employee to carry out their role or continue to carry out the role, or will perhaps enable an absent employee to return to the role. It may be an adjustment that allows them to return if they're in a period of long-term sickness, perhaps. The duty to make reasonable adjustments applies both during and even before employment, where perhaps a job applicant with a disability may require adjustments. So what is reasonable? Reasonable is a widely used word in employment legislation, and that's because what's reasonable will depend on each particular situation. An employer needs to consider carefully when looking at adjustments whether the adjustment will remove or reduce the disadvantage for the person with the disability, whether it's practical to make, whether it's affordable by the employer or the business. If we look at the next slide, it refers to a case that considered whether it was reasonable. It's a case of Khan and Royal Bank of Scotland. It's only an employment tribunal decision, this. So it's not come from one of the higher courts, such as the Employment Appeal Tribunal or the Courts of Appeal, because they create precedents that must be followed by other tribunals. But nevertheless, it's interesting that it demonstrates what might and might not be considered reasonable. Mrs. Khan was a claims handler with Royal Bank of Scotland. In 2002, she suffered a nervous breakdown, and it later transpired that she was also suffering from agoraphobia. As a result, Mrs. Khan found it difficult and increasingly difficult to work to a standard working day because owing to those different anxieties and various anxieties caused by the conditions, she didn't want to travel at busy times. And the employer at that time agreed that she could start work in the morning at 6:30 and work till 2 o'clock. And that arrangement worked well until there were changes to the way claims handling was being administered. And that led to changes to an extent in the way the claimant's office worked. And although it was still open at 6:30 in the morning, and although the people that she needed to speak to, I think she was working quite independently, she didn't need management. So she was told, notwithstanding that there had been an earlier agreement to work from 6:30, she was told that she would now have to work more like what were normal hours, starting at 7:30. And this exacerbated a condition, caused her to become paranoid and suffer more and more anxiety attack each morning before work. Eventually, she had a number of absences and she was dismissed because of those absences, and she challenged them in an employment tribunal and alleged that the employer failed to make reasonable adjustments. The tribunal upheld the claim and considered that once that concept of flexibility was agreed, there was no logical basis for saying that 6:30 a.m. was inappropriate, but 7:30 was. Nothing had really changed other than the fact that the employer, her office was handling claims differently. Her individual job and what she was doing hadn't changed. She could still do it from 6:30 a.m. She didn't need any supervision. The office was open at 6:30 a.m. and therefore the employer couldn't demonstrate why the adjustments couldn't remain so that she could continue to start work at 6:30 in the morning. So that's an example of an employer failing to show why it couldn't make or continue to make reasonable adjustments. Common examples of a reasonable adjustment would be removing an element of a job or role which is causing someone with a disability difficulty. That, as in Mrs. Khan's case, might be changing working hours or shift patterns. It's perhaps something as simple, depending on the condition, as allowing more frequent breaks. It may be alternatively removing something from the workplace. For example, I had a case where an employee couldn't tolerate bright lights near the workplace, and it was just a means of removing bright lights above the employee's workstation. That was considered a reasonable adjustment. It may be alternatively providing something extra in the workplace. It may be providing accessible car parking spaces or space for someone with mobility. It may be providing extra or specialised equipment. It doesn't need to be particularly complex. Another example I've come across in dealing with cases is the provision of a coloured screen filter where someone has dyslexia, and that constituted a satisfactory and reasonable adjustment to remove the disadvantage caused by that person's dyslexia in reading on the screen. There may come a point where it isn't possible to make adjustments to a role or job, or even after making reasonable adjustments, the employee can't carry out the role, or perhaps the disability is still causing an unacceptable level of absence, which continues even with adjustments. In those cases, an employer is possibly required to consider changing roles. There's a case called Archibald 5 Counts, it's a 2004 case, so it's quite a long-standing case, where the court found that it was reasonable to actually fill an existing vacancy, which included in that particular case placing the employee at a higher grade without any competitive interview, because they said it was reasonable to do so. It was a higher grade, but it wasn't particularly a job that the employee couldn't do without a minimal amount of retraining. And they said that employee should have been paid. The employee had got to the position where they couldn't make adjustments, and it was looking at, it got to the stage where they were looking at possibly terminating employment, and the employment tribunal said, well, there was an existing vacancy, it was a little higher, but given that the claimant could have would have been able to do that, so carry out that role with minimal training, they said it was a reasonable adjustment to have placed that employee in that position without going through a competitive interview process. Similarly, if employees' contracts mean they can be moved from job to job, it might be reasonable to move another employee to allow a disabled employee to move into a role that they can carry out. Another case that I would refer to is one called Yelick, Jelic, against the Chief Constable of South Yorkshire, where a police officer who was carrying out a non-public facing role because of having a disability which involved, which was a chronic anxiety syndrome, and who was then required to carry out a public facing role because of a change in his job description, was discriminated against because of a failure to make adjustments, in that South Yorkshire Police failed to consider a job swap with another officer who was in a different non-public role that the claimant could have undertaken. In looking at that as an alternative, I do have to say you would need to look at people's job descriptions and contracts of employment and see if there is that flexibility to move people about. In that particular case, I think police terms and conditions of police officers are such that they can be required to be moved from role to role. And in this case, what the court said was, because of that, they should have moved somebody in a non-public facing role to a different role, allowing Yelick to then move into their role, which would have meant continued employment. I think they were actually retired on ill health. So that's a possibility and should be considered as an alternative, where you get to the point where reasonable adjustments aren't working anymore and you're looking at possibly terminating employment. Always worth keeping a record of reasonable adjustments, both from the employee's perspective and management perspective. An up-to-date record would show that, or would demonstrate perhaps to any new management coming in, saving them having to go through the same process, and it will also make members of management aware of any disability that an employee would have and what adjustments are already in place. And what that does is ensure that reasonable adjustments are correct, practical, and more importantly, up to date. So if we move on to the next slide, which highlights some of the red flags employers should be aware of, and where those red flags occur, they may indicate that you then need to reconsider your steps in light of the fact that you may be dealing with a disability. Don't assume that persistent long-term absences for different reasons may be unrelated. They may look unrelated, but they actually may indicate an underlying condition. I know it's quite an obvious example, but it does occur, and it's something that employers miss from time to time. Look beyond poor or deteriorating performance. Don't take poor performance at face value. See if there's a reason, especially if the employee is usually a satisfactory performer. Uncharacteristic behaviour may be a symptom of something else. Again, in my experience, I remember dealing with a HR manager who was concerned about somebody's conduct and was particularly concerned about the conduct when they got into an investigation meeting. They described that employee as just looking into space, to the extent that it got to the point where they contacted the next of kin because they were concerned about that employee's behaviour. And it subsequently transpired that they did have quite a serious mental health condition, were diagnosed with schizophrenia. So if there's any uncharacteristic behaviour, just check that may not be, again, a symptom of some underlying condition. You need to consider whether there's a disability even where an employee hasn't disclosed it to you. If they have disclosed it, then at that point you may consider need pausing any proceedings that you may be undertaking and get a medical report if you're in a disciplinary process or if you're in a performance management process. Once you become aware or you suspect that an employee may have a condition that's impacting their conduct or their performance and may amount to a disability, then you certainly need to consider whether it's appropriate to pause that process and get advice out. And what that will usually mean is getting a detailed medical report. A lack of knowledge of a disability is a defence to a disability discrimination, but can't be relied on where the employer knows or should reasonably have known, which is called constructive knowledge, that an employee had a condition that was likely to amount to a disability. There's a case called Gallup and Newport City Council, and in Gallup and Newport City Council, I think the employee kept forwarding medical certificates with the same complaints on, which ultimately led to the city council getting a medical report. That medical report, actually, they asked a question as to whether the employee had a disability, and that medical report said, we don't think the employee has. However, a tribunal, when deciding, found that the employee did have a disability, and it's for an employment, not a medical advisor, to determine whether a condition amounts to a disability. And the tribunal said, yes, the employee did. But what they also said was that the employer, notwithstanding the advice in the medical report, the employer should have known or could reasonably have known that the employee's condition was serious and amounted to a disability because of the volume and nature of the sick notes. So that's the fact that an employer says that they didn't know may not always be a defence, because if you should have known or you should reasonably have known, an employment tribunal can find that you should have acted on that. Moving on from disability, if we move on to pregnancy and maternity discrimination, Section 18 of the Equality Act makes it unlawful to discriminate against a woman because she's pregnant, because of an illness related to her pregnancy, because she's exercising, seeking to exercise, or has exercised a right to take maternity leave. This section makes it unlawful to discriminate in a protected period. In pregnancy and maternity claims under the Equality Act, the protected period is when the pregnancy begins and it ends when either ordinary or additional maternity leave ends. One of the problems, or one of the areas which we find causes problems, is where an employee who's pregnant or who's on maternity leave is placed at risk of redundancy. However, in circumstance of redundancy, not only might we be looking at potential discrimination under the Equality Act, but employers also need to consider, and you may be aware of this regulation, Regulation 10 of the Maternity and Parental Leave Regulations of 1999. If we look at the case of Wainwright and Sefton Borough Council, this is a case I'm quite familiar with. I left the co-op for a couple of years, and during that time, before coming back, I worked in private practice, but I also worked as a locum solicitor at Sefton Borough Council. As I left the co-op, I joined Sefton Borough Council 2 days later and walked straight, I was the only employment lawyer there, and walked straight into this case of Wainwright and Sefton Borough Council. It had started, it was actually, they'd had a tribunal decision at that point, and it was at the Employment Appeal Tribunal, but I picked it up, and it was an interesting case. It involved claims both under Section 18 of the Equality Act and also under Regulation 10 of the Maternity and Parental Leave Regulations. And what Regulation 10 of the Maternity and Parental Leave Regulations provides is that where an employee on ordinary or additional maternity leave is potentially faced with the redundancy or has been selected for redundancy, she's entitled to be offered any suitable alternative available vacancy. It's a bit of a common misconception in that this criteria is simply satisfied by allowing the employee on maternity leave to apply for a role, and that will be enough. They make the employee aware of the role and they apply for it. it isn't. The law is quite clear that if a suitable alternative vacancy is available and it's not offered, then a redundancy dismissal where a female is on maternity leave will be automatically unfair if there is an alternative vacancy that's suitable that that employee hasn't been offered. So what Regulation 10 does, it gives the employee on maternity leave priority over other employees who are also at risk of redundancy. And it's a rare example of lawful positive discrimination. Whether a vacancy is suitable will be determined by the capacity, the job role, the place of employment and other terms and conditions, and provided they're not substantially less favourable than under the previous contract or position. There is a subtle difference between when an employee is protected under Section 18 of the Equality Act and when they are protected under Regulation 10 of the Maternity and Parental Leave Regulations. As mentioned, an employee is protected against discrimination on the grounds of pregnancy and maternity under the Equality Act as soon as she is pregnant, whereas the protection offered by Regulation 10 only applies during maternity leave. That case of Wainwright and Sefton Borough Council is a leading case in authority in the area. And what it concerned a male and female employee. The female employee was Michelle Wainwright. They had slightly different but similar grade jobs in the same department. A restructure meant that both jobs were deleted and replaced by a single, slightly higher grade role, which they were both considered suitable for. At the time the decision was made to delete their existing roles, at the time of that restructure becoming a formal restructure, the claimant, Mrs. Wainwright, was on maternity leave. Both candidates were interviewed for the new job. The male employee performed better at interview and was placed into the role. Mrs. Wainwright challenged this and said it was a breach of Regulation 10 of the Maternity and Parental Leave Regulations, and that it was pregnancy and maternity discrimination under Section 18 of the Equality Act. What the court said was, although they found there'd been a breach of Regulation 10, it found that it didn't necessarily follow that she'd been discriminated on the grounds of pregnancy and maternity. And since the male employee had performed better at the interview, it found that the claimant had not been discriminated on the grounds of pregnancy and maternity, although it did say that she had been automatically unfairly dismissed because she should have been placed into this new role automatically, not offered the job, shouldn't have been interviewed for it, should have been placed into the role. So they said that was a breach of Regulation 10, but what they also said was actually it wasn't discrimination on the grounds of pregnancy and maternity, because the reason she hadn't been offered that was that the male candidate performed better. So the difference between this Regulation 10 is that it requires preferential treatment of an employee on maternity leave, whereas Section 18 of the Equality Act requires less favourable treatment on the grounds of pregnancy and maternity. There's a slight difference. One requires preferential treatment, the other requires, for a finding of unlawful discrimination, for there being to have less favourable treatment. So when is Regulation 10 triggered? Regulation 10 is only triggered once the employee has been selected for redundancy. The fact that an employee is pregnant and on maternity leave shouldn't be factored into the selection process itself, so that an employee on maternity leave is excluded from a redundancy selection process. An employee on maternity leave can be selected for redundancy, but this Regulation 10 then applies once she's selected. If you don't put a female employee who's on maternity into the selection process, you are at risk of a claim from a male employee who says this isn't the fair selection process. That employee wasn't part of the redundancy selection process. So the employee should be part of the selection process, but when they are selected, if they are selected, that's when Regulation 10 the Maternity and Parental Leave Regulations apply. Just looking at another case, that of Larkin and Liz Earle Beauty, it's quite a recent case. This, again, it's only an employment tribunal decision, and again, not a decision of a higher court, so not binding. But it does illustrate the way employment tribunals must approach discrimination claims. Mrs. Larkin was employed by Liz Earle Beauty as a marketing manager in 2013. In January 2017, the company recruited a senior manager tasked with carrying out a restructure. In February 2017, the senior manager met with Mrs. Larkin and held what was described as a positive meeting with her. In fact, she identified, or they identified, some development opportunities for Mrs. Larkin. Shortly afterwards, she made her employer aware that she was pregnant. And what she said was at that point, the employer's attitude towards her changed, and despite the positive meeting, she was identified in the restructure as being at risk of redundancy, even though not long before they were identifying development opportunities for her. Another important factor in this case was shortly before the redundancy took place, Mrs. Larkin's immediate line manager handed in a notice, but her immediate line manager was told not to tell Mrs. Larkin or any of the others that she'd handed in a notice. Consequently, although Mrs. Larkin was still in the business at the time of redundancy and hadn't commenced maternity leave, she wasn't made aware of the potential vacancy that her manager leaving had left, and wasn't consulted about it as a possible alternative to redundancy. In discrimination claims, tribunals must look at it in a certain way. The burden is initially upon the person alleging discrimination to show that in the absence of a valid explanation from the employer, there are facts from which an employment tribunal can conclude that discrimination has occurred. At that point, the burden switches to the respondent to show there's been no discrimination. And that's usually the point when it starts to become a bit warm and a bit uncomfortable in an employment tribunal, because once that burden switches, then it's for the employer to provide an explanation. And if they haven't been able to do so already, they're generally struggling. In this case, what the employment tribunal found was that whilst there weren't facts from which it could certainly or conclude with any certainty that there'd been discrimination in respect of Mrs. Larkin being identified at being at risk of redundancy. So they said it wasn't obvious that the pregnancy put her at risk of redundancy. What they did say was the failure to consider her for the vacant managerial position and to carry out a proper consultation did amount to facts from which it could be concluded there'd been discrimination. That's the way employment tribunals are required to look at it. There doesn't need to be any intention. Sometimes there is, but there doesn't need to be. They just need to satisfy the definition of legislation. If we look at some red flags in terms of maternity, in terms of redundancy, we've looked at the application of Regulation 10, but that is still an area where employers make mistakes, and therefore something that employers need to be aware of when an employee on maternity is involved in a redundancy process. In instances where there may be either a disabled employee or a pregnant employee who may be at risk of redundancy, the redundancy selection criteria is another factor that should be carefully considered. The Equality Act imposes a duty on employers to make reasonable adjustments to their practices and procedures so as not to put disabled employees at a substantial disadvantage. And that obligation to make reasonable adjustments applies to redundancy selection criteria. Similarly, an employer should take care that redundancy selection criteria doesn't discriminate against employees who are pregnant or on maternity leave. For example, if an employee's absence is connected with pregnancy and maternity or has a consequence of disability, we looked at discrimination arising from disability earlier. So if an employee's absences are connected with, if an employee has some absences connected with maternity or pregnancy, or has some absences arising as a consequence of disability, they shouldn't be included when scoring an employee on a level of absence or in failing to meet attendance targets, which may ultimately impact on whether they're made redundant. In terms of pregnancy, always conduct a risk assessment and consider high-risk environments. An employee is obliged to conduct a risk assessment when an employee notifies them of a pregnancy, and not to do so could amount in itself to a grounds for claiming discrimination on the grounds of maternity and pregnancy. In terms of recruitment and promotion, clearly the fact that an employee has a disability or is pregnant or on maternity should not be a factor in that employee not being considered for promotion or even in the recruitment process. Employees on maternity leave should be consulted about any proposed redundancies, any reorganisation or any vacancies, so that they have the same information as those people who are at work. Certainly worthwhile considering a system of notifying employees on maternity leave of when vacancies arise. That might involve perhaps a regular general email listing all vacancies, or it could be more personal contact where a vacancy perhaps exists in an area in which the employee is interested in. Moving again to some common mistakes that we've considered and things to look out for and avoid. Failing to make reasonable adjustments, it still goes on. Pressing on with formal processes, regardless of the fact that you've may become aware that an employee has a protected characteristic and that characteristic may impact on that process. In that case, look at pausing it, look at taking further advice, look at getting further information. What you really need to know in those circumstances is what you're dealing with. If you don't know what you're dealing with, there's always going to be a potential problem. And the most common mistake there is not obtaining medical evidence when, as an employer, you're going through a process and you're made aware of the fact that somebody has a disability which might impact on that process. Failing to consider a woman for a suitable vacancy when she's on maternity leave, that's Regulation 10 we've touched on, but still a common mistake. Those regulations have been in since 1999. That Sefton case was a 2014 case. So employers are still making those mistakes, 10 years after the implementation of those regulations. And again, failing to perhaps consider a woman for promotion because she's on pregnancy, because she's pregnant, or because she's on maternity leave. That would be contrary to Section 8 of the Equality Act. That's just a bit of a quick run through of discrimination, types of discrimination, protected characteristics, and in particular 2 areas that we find cause problems.
That's brilliant. Thanks ever so much, Gary. So I've got some questions to ask you, if that's all right. So the first one, you've looked in some detail about disability discrimination, but there are some conditions, aren't there, that are excluded from disability legislation. Can you talk us through those?
Yeah, some conditions are excluded. I think that they're not contained in the legislation, they're contained in guide, and I think they're contained in some secondary legislation, the regulations to the Equality Act. So not the Equality Act itself, but there are some conditions that are specifically excluded from disability legislation. So these conditions won't or can't constitute a disability. They include addiction to or dependency on alcohol, nicotine, so smoking, or in fact any other substance. So if you've got a drug dependency or an alcohol dependency, that won't amount to a disability. The only time it might do is if they've been medically prescribed for you, if there's been some drugs that are medically prescribed and they are having this adverse long-term substantial effect on your ability to carry out day-to-day activities. The other one that comes to mind is hay fever. That's specifically excluded. There are certain other conditions, people who have a condition, I can't remember what it's called, but where they have a tendency to set fires, that's not covered by the disability and is excluded. And where there's a tendency to steal, that is specifically excluded as a disability. That's not a disability. So
thanks, Gary.
There are some conditions that are specifically excluded.
How about obesity, Gary? Is being obese considered a disability?
It can. a disability, if you look at the definition, a disability under the Equality Act is a physical or mental impairment that affects a person's ability to carry out normal day-to-day activities. It must be substantial, as we've seen, and it must be long-term. I think whether obesity is a disability would depend on the extent and the effects of the obesity. Moderate obesity, probably unlikely to be considered a disability, but more extreme cases are likely to be considered a disability. And I think there was a case, I can't remember the name, there was a case in Ireland that they found, it was in Northern Ireland, that they found that obesity was a disability. I think what employers have got to bear in mind is that obesity sometimes occurs as a result of other medical conditions, such as perhaps diabetes. So obesity is associated with diabetes. The obesity may not be a disability, but the fact that it's been caused by a condition, another condition, may have an impact because that other condition may be a disability. So even if this obesity can be, but even if it's not, what you need to look at is whether there's some other underlying condition that might be causing the obesity.
Thank you, Gary. You talked at some length about reasonable adjustments and the obligation to make reasonable adjustments. What sorts of things would an employment tribunal take into account if they were considering whether or not a proposed adjustment that hadn't been made, should have been, whether or not it was reasonable, would have been reasonable to make that adjustment?
Tribunals, what they would look at is whether the adjustment that could have been made would have removed or alleviated any disadvantage caused by the disability. You might have an employee who's insisting on a certain adjustment being made, but what is relevant to that is whether that adjustment would actually remove the disadvantage caused by a disability as required by the Act. If the employer is refusing to make that adjustment, well, like I say, that the tribunal would look at it whether the adjustment would have removed or alleviated any disadvantage. They'll also consider whether it was practical or practicable, and they'd look at the costs, and in doing so would look at the size of the employer and the resources available to the employer. All of those are things that a tribunal would look at in deciding whether it was reasonable to make an adjustment or not.
Thanks, Gary. If an employee has a disability, which means that they can't do their job properly, what options are open to their employer?
Well, provided there's a disability at play, then an employer's got to make those reasonable adjustments, as we've discussed, and that could take various forms. It might be removing elements of the role that may be causing difficulty, so removing a particular part of a job. It may include providing equipment or assistance, and that again might be a simple adjustment. Like I said, the example I gave was I dealt with somebody who had dyslexia, and I think they agreed to put a yellow screen or filter on the computer, which made it easier to read. So it could be providing equipment or assistance. It could be changing terms and conditions, not just removing elements of the role that an employee can't do, but perhaps changing hours or shift patterns, as in the case we've looked at, the case of Khan. Ultimately, if none of the adjustments are working and the employer has got to the stage of perhaps considering dismissing on grounds of capability, it will definitely include looking at the possibility of a different job for the person with the disability.
Thanks, Gary. Elaine is asking whether there's a limit to reasonable adjustments, or can they just continue and keep changing for an employee?
They can keep changing, Kate. I think one of the things we looked at in the webinar quite briefly was the fact that you ensure that adjustments are up to date. In terms of medical conditions, they quite often change, and as an employer, you need to be aware of those changes. An employee obviously should make you aware of them, but the alternative, if the employee's not particularly coming forward at making adjustments, is to get a medical report and get updated medical reports. Like I say, you can have certainly progressive conditions amount to disabilities if they're serious enough, and certainly conditions that progress may require different disabilities at different times. There may come a stage when you can't make any more adjustments, or the adjustments that you now need because of the changed condition are no longer reasonable. One of the other reasons I think you need to look at making sure you've got an up-to-date understanding of someone's condition is sometimes I found that one of the things employers aren't aware of sometimes is that even though the condition may not change, the medication that somebody's on might change, and that medication may have an impact. So as an employer, I always say you really need to know what you're dealing with. That would determine what type of adjustments you can make. Yes, adjustments will change over time, and yes, there may unfortunately come a time when you can make no further adjustments, or the adjustments you can make are no longer reasonable. But what you really need to do is make sure that you're up to date with that employee's condition, either by speaking to the employee themselves or by getting medical reports and updating them.
Thank you, Gary. We talked about this briefly in the actual webinar, you touched on it, but if an employee did disclose a disability during a formal process, a disciplinary process, for example, would it be appropriate for that process to continue?
My advice would be to investigate the disability and how it affects the employee. And that will almost certainly mean pausing the process. As an employee, you're going to need to consider whether the disability, or as I said, any medication that they're on may have had an impact on the employee's conduct or performance that you're investigating. And again, in doing that, in investigating that, you're probably almost certainly going to need to obtain a medical report. So my advice would be, yes, if somebody's telling you something in a hearing, perhaps an investigation hearing, perhaps a disciplinary hearing, that you think might have an impact in terms of the outcome of that hearing, and whether an employee has a disability and whether that disability may have contributed to either the conduct or any poor performance, you need to investigate that. You need to know what you're dealing with, and it may not be appropriate to continue with that. I think I gave an example during the webinar of when I got a call from a HR manager who was concerned about somebody who they described as looking into space. That was in a disciplinary hearing. Ultimately, they investigated the concerns. The employee had a significant mental health condition. And obviously at that point, it was decided that it wasn't appropriate to continue with the disciplinary hearing. It may be after investigation that is appropriate, but as I say, you need to know what you're dealing with. And the only way you can do that is to investigate. So it probably does mean pausing that process.
Thanks, Gary. So we've talked about women who are on maternity leave and who are pregnant being protected. But what about a woman who's returned from work but is still breastfeeding? Is she protected from discrimination as well?
So it's come off maternity leave, back in work, but is breastfeeding. To an extent, she is. The legislation doesn't give any right to breaks for paid breastfeeding, but it does give some protection, because if somebody's breastfeeding, what health and safety law or legislation says is that an employer must provide somewhere suitable for a breastfeeding employee to rest, and if there are any risks to the mother or the child because of the breast milk, i.e. I'm thinking of contamination of the breast milk, then the working conditions are something that the employer's got to take into account. They need to carry out a risk assessment, and if that in any way, if there's any concerns or any perhaps hazardous conditions or substances, then yes, the employee is protected. They can't be put in that position, and in those circumstances, you probably look at changing some of the working conditions or removing the risk. You know, if somebody's dealing with a hazardous substance and the breastfeeding, then make sure that element of the role or that element of the job is removed. So yes, to an extent, there is still some protection. Yeah.
Lovely. Thank you ever so much, Gary. Well, we haven't had any more questions come in, so I think we're going to draw it to a close there. Thank you so much, everybody, for joining us today. I do apologise for our technical issues at the start. Hopefully that didn't detract from the webinar too much for you. I hope that you found that useful and you feel like you've got a better understanding of discrimination law and some of the obligations that you're under as employers. Please remember that if you are a member of Co-op UK, if you've got the contact or the HR package and you've got specific questions that you'd like some advice from, please do get in touch. That's what we're here for. So we'd love to hear from you. It's a really, really big topic. We're so conscious that we've only just been able to touch the surface today. So we are really interested in understanding from you whether or not you'd find it useful to have a more detailed, in-depth session. So if I may, I'm just going to run one more poll very quickly just to understand whether or not that's something that you'd be interested in. It's ever so helpful for us to understand the sorts of topics that you find it useful for us to run training sessions on. So if you could get in touch with us, if there's anything that you're thinking, actually, that would be ever so useful and we're not offering it, then please do let us know and we'd be happy to set something up. It's been great to have you all join us today. I hope you found that useful and hopefully we'll see you again soon. Take care and enjoy the rest of your afternoon. Thanks, everybody.